A federal district court just placed an injunction on a race-based farm subsidy scheme that the Biden administration has actually been running for a few years now. But before we can celebrate the end of this thing, it's actually essential to look at the good and the constitutionally not so good portions of this decision. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and here's the story. In a move that reveals both how much the Biden administration seems to love to engage in racial prejudice and reveals the gulf between what the U.S. Constitution actually says and what many contemporary Americans claim it says, a federal court in Texas last Friday issued an injunction against the United States Department of Agriculture's, the USDA's, race-based disaster relief program that Biden and Congress started as part of their so-called American Rescue Plan in 2021. You probably remember that plan. It took $1.9 trillion from us and our progeny and gave it to politically favored interests, all under the guise of helping people during the lattice of government-mandated lockdowns, tragically called COVID response. It's been 3 years since their parthenogenic, tax-eating, problem reaction solution bill passed, and now presiding Judge Matthew J. Kacsmaryk and the U.S. District Court for the Northern District of Texas have issued an injunction against 8 USDA handout tracts, all created under the guise of helping farmers recover from a natural disaster, be it COVID or the weather. Entitled Strickland et al. v. U.S. Department of Agriculture, that's Vilsack et al., and filed in March, the plaintiffs worked with the Denver-based Mountain States Legal Foundation and the Southeastern Legal Foundation, SLF, and as Farm Progress noted in May, quote, they claim that the USDA improperly discriminated against them in administering various disaster and pandemic relief programs. Plaintiffs in Strickland v. USDA challenged the USDA's disparate treatment for certain producers based on race and sex. The plaintiffs assert that the USDA violated both the Equal Protection Clause of the U.S. Constitution and the Administrative Procedures Act. Now, the latter accusation Friday was affirmed by the court, and it cited the USDA's manipulation of the 2021 American Rescue Plan as the agency calculated and directed their relief funds in a manner called progressive factoring, something not specified by the actual 2021 statute. As John Solomon in April wrote for Just the News, quote, the farmers said the Biden administration has taken roughly $25 billion in disaster and pandemic aid approved by Congress for farmers in 8 programs and devised a system to make awards based on race, gender, or other socially disadvantaged traits. Such decision-making violates the Constitution's Fifth Amendment and the Administrative Procedures Act. The Constitution promises equal treatment to all Americans, regardless of their race or sex. The court filing also reads, it also promises the separation of powers. USDA broke both promises through the disaster and pandemic relief programs challenged here. And Friday, Judge Kacsmaryk's court agreed, which is good and not so good. Going beyond the very clear maladministration issue noted earlier and beyond the executive branch warping of the original handout plan, a curious observer faces the second half of this case pertaining to the equal treatment cited earlier, and also to the fundamental misreading of the Constitution in which even this court has engaged. To be specific, the Fifth Amendment is not at play here. The so-called equal treatment cited is a misreading of the 14th Amendment's Equal Protection Clause. And the misreading reveals just how poorly many people understand the founders' original rationale for government. The founders expressed through the Declaration of Independence, the Articles of Confederation, and the U.S. Constitution that governments are supposedly created to protect people from aggression and harm initiated by other people. Thus, the Equal Protection Clause requires states to equally enforce their protection statutes. The clause is not the Equal Treatment Clause, as in when the government hands out treats, like money to farmers, it's got to do that in some kind of equal manner. Such an idea is, of course, immoral from the start, because it takes from some and gives to others for so-called natural disasters like storms, or in the American Rescue Plan schema for COVID relief. But it also indicates that the contemporary view of government is drastically different from the original of the founders here in the United States. This mistaken view is so pervasive, even people suing to stop an unconstitutional government program don't cite the proper section of the Constitution, and even judges don't express the fact that the 14th Amendment is not about equal handouts. The government isn't supposed to be engaging in handouts. As Misty Severi reported Friday for Just the News, the Southeastern Legal Foundation celebrated this victory and reminded readers that this is not the only instance of the USDA engaging in racial preference with slices of pork pie. Quote, the court's nationwide injunction ordering the USDA to stop discriminating against farmers in the administration of disaster relief programs because of their race or sex represents a win for freedom and equality, the Southeastern Legal Foundation told Just the News in a statement. USDA has tried this before with other programs. SLF has taken it to court and won. We won't stop fighting for the constitutional rights of American farmers until USDA earns their trust through fair and equal treatment. Indeed, the New York Times reported in 2021 that Judge Marsha Morales Howard of the U.S. District Court for the Middle District of Florida in Jacksonville temporarily blocked the Biden USDA from making loan forgiveness payments, i.e. handing people money to pay off loans, to minority farmers. Minorities. Well, as Ayn Rand said, the smallest minority on earth is the individual. And until people begin to realize that all forms of government, be those forms enacted for socialist so-called relief programs or for supposed protection against other people, until people see that all forms of political action actually undercut our sovereignty as free individuals to control our lives, well, this kind of pandering, be it racial or tailored for some other public relations purpose, it's going to continue. From a philosophical standpoint, the founders actually opened up Pandora's box by assuming government can take your money to protect you. And of course, it was only a matter of time before politicians would start to add extra dangers to their rationales for government so-called protection. Dangers beyond other people, dangers like weather and fires, even viruses. More and more and more, until the so-called idea of protection became molded into the idea of treatment by the government. Well, we're not animals. We don't need handouts, and we don't need government treats. And the only way government hands out those treats is by taking things from other people. That is immoral, and we can recognize that immorality as these battles over which squeaky wheel gets the grease play out. Thank you for watching, everybody. Thanks for digging into the philosophy from this contemporary breaking issue, this big court story, and perhaps carrying some lessons along and passing them on to others. Remember, you can find our videos without censorship on Rumble. Please follow us there and share the videos far and wide. Of course, you can find us on YouTube where they do censor us. And please visit MRCTV.org. That's MRCTV.org to find out what the whole team is doing. Just open up another tab hop on over there and check out what everybody's doing. And while you're there, please consider donating to the Media Research Center and check out the MRC-TV store. You can also find us on Facebook, TikTok, Instagram, on X, and if you want to find me on Gab, I'm at Gardner Goldsmith, and on X, I'm at Gard Goldsmith. For MRC-TV, thanks for watching. Please share. I'm Gardner Goldsmith.
I want to invite you as my guest on a very special, once-in-a-lifetime, 7-day post-election cruise in the Caribbean. It's going to be a blast.